In today's video, we're talking about theft of means of transportation. It's a fancy way to say stealing a car, otherwise known as grand theft auto in other states. Theft of means of transportation is somewhat common. There are 5 different ways that somebody can be charged and convicted with theft of means of transportation. In this video, we're going to run through the 5 different varieties of theft of means of transportation. Let's look at the statute, and I will explain what level felony each one of these are. So first, let's take a look at the statute, A.R.S. 13-18-14. If you pull it up or throw that number into Google, you'll see these 5 different subsections here. Each one of these individually is a way that a person can be charged with theft of means of transportation. Means of transportation is just a fancy way of saying a vehicle, a car, a motorcycle, some sort of way that a person is transported from one place to another place. What's the means of that transportation? That's what we're talking about here. So here, MOT stands for means of transportation. Just for simple understanding, you can consider it to be a car. So the first way that somebody can be charged with theft of means of transportation is if they are controlling another person's means of transportation with, this is important, intent to permanently deprive of the means of transportation. So they are controlling another person's car with the intent to permanently deprive them of their car, meaning they have no intention of ever bringing this back. There's another statute in Arizona that's called unlawful use of a means of transportation. So that would be somebody borrows this car, they use it for the day, they had no permission to do that, but they had every intention of returning the car back to the true owner. In this situation, that person had intent to take it and never bring it back. That would be intent to permanently deprive that individual of their vehicle. The other way that a person can be charged with theft of means is if they are converting a vehicle for an unauthorized term or for a use that is not otherwise permitted. So let's say, for example, somebody gives this car to me, but they say I can only use it for a certain activity. I can only use it to go from point A to point B. But I take the car and I use it to do a bunch of other stuff. I take it from points to B to C and D to E and all around town, and I do it all for my own purposes. Well, I was trusted to use it only for a very limited purpose. I had only very limited authorization, and I had converted that limited authorization into a big variety of other things that I can do that I was never authorized to do. So essentially what I've done is I've stolen that vehicle for other purposes where I had no permission for it. And so you can convert it, and that is a way that you can be charged with theft of means of transportation. You're essentially stealing that vehicle for other purposes. The other way that you can get theft of means is if you obtain a means of transportation by material misrepresentation, this is a legal term, with the intent to permanently deprive the person of that means of transportation. So let's say, for example, that you go to an individual and you ask them to donate this car to charity, and they do that, and in fact there really is no charity. You're going to take that car and use it to drive all over the country. Well, you have materially misrepresented the purpose for you receiving the car. And so if you've obtained that car through that material misrepresentation and you don't have any intention of ever giving that back, you've told a person you're going to use it for charity, they gave it to you, use it for another purpose, they find out about it, call the police on you. Well, because you were going to permanently keep that car, you can now be charged with theft of means of transportation. The fourth way that you can get it is if you received a lost or a misdelivered vehicle, and you can, under the ordinary course of things, discover who the actual owner was, who it should have been delivered to, and you don't take reasonable precautions, you don't actually do anything in order to go find the true owner, and you could have or should have, that can be you could be charged with theft of means of transportation. So if this car was supposed to be delivered to somebody else, but it ended up on my doorstep, or the deed was transferred over to me for some weird reason, or something happened, or the title of the car, not the deed, it was transferred over to me, and I could have found out, no, I should have done this, and it really should have gone over to this person, but I kept it, I used it for my own personal purposes, and I never did anything with it to go actually give it and correct the situation and give it to the rightful owner. That's theft of means. I've now taken that vehicle, it's not mine, I've used it for my own personal purposes. And finally, the last way that you can be charged with theft of means of transportation is if you are controlling another person's means of transportation and you either know or you have reason to know that the means of transportation was stolen. So if you are controlling it, meaning you're using it for your own purposes, but you know it's stolen, somebody else maybe stole it, or they took control of it with intent to deprive somebody else of its use, and now you take it, and you know it's stolen, or you should know based on the circumstances surrounding the situation that it was in fact stolen, and you use it for your own personal use, that's theft of means of transportation. In Arizona, this is a very serious felony offense. We have 6 different classifications of felonies. So class 1 is the most serious level of felonies. It's at the very top. It's really only for murder and those types of offenses. We have class 6, which is all the way at the bottom. So that's for the lowest level felonies. All felonies are serious, but class 6 is the lowest level. This is a class 3, so it's right in the middle there. It's very serious. Any one of these is a class 3 felony. There are defenses to each one of these different types of theft of means. It's going to depend which one you've been charged with. It's going to depend upon the facts of your specific case. But it is a serious thing. You need to make sure you understand what you're facing. If you've got prior felony offenses, you could be potentially going to prison for a very long period of time, depending upon a lot of the circumstances. So I'm not saying that to scare you if you're watching this video. I'm saying it to tell you this is a serious charge. You need to make sure you understand it. You need to make sure you have a good defense attorney and a good team of people who will help you understand your situation and ensure that you have the best defense possible. Give our office a call if you've been charged with theft of means of transportation. If somebody you know or love has been charged with theft of means, give us a call. We offer free case evaluations. We'll go through your case. We'll discuss all of your options. We'll make sure you have a good plan. And like I said, most importantly, that you have a team of defense professionals you can trust to get you through this with the least amount of damage possible. Give us a call. We look forward to speaking with you. Hang in there. Thanks for watching. We'll speak to you soon. Take care.